Given the state of this evidence, a reasonable mind could not fairly conclude the guilt of the accused beyond a reasonable doubt, even when the evidence is construed in the light most favorable to the state. If you accept as true the evidence you've heard from the witness stand, you must reject as false other evidence you've heard from that same witness stand. As I've attempted to illustrate in my review of the evidence the court has heard thus far, it's not possible to accept as true everything you've heard, because what you've heard from that witness stand has been contradictory. It has refuted other testimony from other doctors. The opinions that were admittedly by Dr. Davis and Dr. Glick, both subject to being wrong, were premised upon facts that, if true, would render the opinions false. Consequentially, we believe that no reasonable mind could find beyond a reasonable doubt based on even considering the evidence in light most favorable to the prosecution that they're guilty of guilty. Finally, I think it's important to note the government never proved venue. You didn't hear from any witness, and we poured over this to make sure we were right. We didn't hear from any witness that all of the facts about which testimony was provided occurred in the county of Whiteside, state of Illinois. As an officer of the court, I'll tell you, I think there was some testimony elicited with respect to Mrs. Mock's residence being in Rock Falls, but my understanding is that there are parts of Rock Falls that may not be in Whiteside County that was never established that what you heard occurred in the county of Whiteside, state of Illinois. I also note in the government's response to the defense motion for directed verdict of acquittal that proposed for the prosecution's case, that the government failed to address that point, and it's not an unimportant one.
Obviously, it was an event that took place on April 21st that resulted in the child going to the hospital. There was a different event on September 24th, wherein the child was taken to the hospital. The signs preceding these events may have been similar, but certainly the results, at least based on the evidence so far, of these two events are extremely different. That on April 21st, the child was checked out at CGH up in Rockford and released to return home the next day. The undisputed evidence from that point on is that he seemed to be a normal, healthy child for a period of 5 months leading up to September 24th. The September 24th incident resulted in the child being taken to the hospital where immediately an acute, ongoing subdural hematoma was detected on his brain. He was taken to Rockford, where CT scans again were done and MRIs that showed damage to the brain, the bilateral retinal tearing, and subsequently the injuries to the child's brain resulted in his death. Certainly two different things from September to April 21st. At this point in time, Your Honor, the evidence before the court is that in the opinions of Dr. Davis and Dr. Glick, supported by the opinions of Dr. Bloom, this child sustained an acute subdural hematoma on September 24th. He subsequently was discovered to have had swelling of the brain and the bilateral retinal hemorrhaging, which Dr. Case testified that based on the staining she used, there were two distinct different patterns, one which was, in her opinion, clearly indicative of abusive head trauma.
She had to knowingly kill the infant. You've heard not one shred of testimony that would support that proposition. There's been no evidence of motive. There's been no evidence of intent. The testimony that you have heard during the prosecution case in chief actually refutes the proposition that there was intent or knowledge. The testimony you heard from the prosecution's own witness, Connie Delgado, was that Patti Mock was happy, laughing, nurturing when she left the residence at 11:55 a.m. The testimony you have from David Northcutt is that when he entered the residence, Patti Mock was lying on the floor next to the infant, rubbing him, consoling him, and comforting him. The testimony you have from other paramedics and firefighters is that Patti Mock was calm. There is no evidence to suggest that she was angry, frustrated, or that she knowingly and intentionally caused the death of this infant. No evidence whatsoever. So on that mental state component, which is so crucial to the first-degree murder prosecution, you've heard absolutely nothing. And no reasonable mind could find, beyond reasonable doubt, that Patti J knowingly killed this infant.